I'm John Chowning with Campbellsville University and very pleased to welcome you to another segment of Dialogue on Public Issues. From time to time, I'm very pleased and honored to be interviewing state officials. And today, one such official, newly elected and newly sworn in, is our Supreme Court Justice for this part of Kentucky, the Honorable Deborah Lambert. Justice Lambert, welcome.
Thank you, Dr. Chowning.
I've known you through the years as Debbie, but I'm going to call you Justice Lambert today.
You may call me whichever you please. Thank you very much.
Well, congratulations, by the way.
Thank you. I'm excited.
Tell us a little bit about yourself. You're really no stranger to Campbellsville. Our folks know you quite well.
Yes, I enjoy Campbellsville very much. I was previously on the Court of Appeals, and Taylor County has always been very supportive of me as their representative on the Court of Appeals, and now their representative on the Kentucky Supreme Court. I'm pleased and honored to have the trust and confidence of the local people here.
Now, you've also were you a district judge or circuit?
I was a circuit court judge,
okay.
Yes. Started the First Family Court in Pulaski County, and am honored to now be a judge or a justice with family court experience on the Supreme Court bench.
That is a very distinguished record, and certainly your two other levels in the Court of Justice certainly prepare you for that. Why did you decide to run in this particular election cycle?
Well, I thought that Justice Venters was doing a perfectly fine job. However, he decided to retire at the end of his current term, and though the timing wasn't perfect for me in my own evaluation, the time was right for me to offer up my experience. One of the good things I think that I bring to the table is I practiced law over 16 years, and I feel that has given me a bit of insight as to the needs of the everyday litigant, and I think that will help me in my policy part of my role as justice, and hope to serve the people a little bit better. Now,
were you a prosecutor or a general practice of law, or all the above?
Well, all of the above, really. In that regard, I practiced law in Mount Vernon, Kentucky, and surrounding areas, but I was an assistant Commonwealth's attorney for a time period early in my career, and have done a modest amount of criminal defense work as well. So I had a little bit of both.
I would think that would serve you well in terms of being at the highest level of the appeals court system of jurisprudence, and having been on both sides of the table, so to speak, in the practice of law, and then you've been circuit judge, Court of Appeals judge, and now Supreme Court justice.
I hope it does. Hope it does.
Now, you represent a rather large area. Tell us how the districts are comprised in general, and approximate territory that you actually cover.
Well, there are 7 appellate court districts in Kentucky. Our district number is the 3rd district, and for those who might be interested, there is a web page, courts.ky.gov is the web page that shows the maps. But I actually am elected from 27 counties, and the 27 counties go from on the Kentucky-Tennessee border, Bell County, which is my actual home county, where I grew up. I used to tease people when I was traveling around campaigning, and I'd have the line, "Oh, I'm countrier than you," and we would laugh, and I would explain growing up in the beautiful mountains of southeastern Kentucky. So I'm very proud of that. But the district travels from Bell County along the Tennessee border over to Monroe County, then goes northward to Nelson County, in fact. So, and then dips back down under Boyle County, goes over to the east to Estill County and Lee County. Lee County is the home of the Woolly Worm Festival, one of my favorite festivals in Kentucky, and then goes on back and collects Leslie County in the east.
That's a large territory.
It is a large territory.
And does include the mountains, but also the hills of South Central Kentucky.
Yes. It's a beautiful state we live in.
It is, and a very diverse territory that you're covering. Now, you mentioned that there are 7 members of the Kentucky State Supreme Court. What are the duties of a Supreme Court justice and the court as a whole?
Well, the primary duty is to, of course, timely and adequately provide a review of cases. And the Kentucky Supreme Court is the court of last resort in Kentucky as to Kentucky law, and it's a high responsibility, and I guess each day I get another reminder of that here early in my role as a justice. We decide the direct appeals on death penalty cases, and any case that any criminal case that receives 20 years or more in punishment. So the cases come as a matter of right that are criminal cases with 20 years or more to the Supreme Court, and we literally sometimes hold the life of that individual and the community's responsibilities right in our hands. And so every file holds the life of a human being or the lifeblood of a business. It's very important to the litigants that they get a fair and impartial.
So there are
review.
certain capital cases or certain type of felony cases that would be automatically appealable to the state court, Supreme Court, bypassing the Court of Appeals.
The Court of Appeals if it's 20 years or more, yes, sir.
Then other cases would be those of lesser penalty would go first to the Court of Appeals.
Yes, in those cases, their matter of right appeal, their first appeal, their one appeal that's guaranteed by the Constitution goes first to the Court of Appeals. It's just with the more severe punishment, the higher level of criminal responsibility comes directly to the Kentucky Supreme Court.
Does the Supreme Court review civil cases on occasion?
Yes, often. Review all of those, and then we are also responsible for court policy making and rulemaking. So, for instance, rules of evidence and any modifications to those rules go through the Kentucky Supreme Court.
And those would then have to be followed by the lower courts in the justice system. Now, what type case would typically, you've mentioned some in general, but what would a typical case, if there is such thing, that would reach your desk, so to speak, that in you and your 6 colleagues?
Well, I am just now going through the cases that are assigned to me for the first month in service, but typically it's going to be a lot of criminal cases, some civil cases. There will be some attorney discipline cases. We do also review the attorney discipline cases that come out of the Kentucky Bar Association, and also the judicial discipline cases, judicial retirement and review cases.
Would there ever likely be a case, Justice Lambert, that would go from the state Supreme Court into the federal court system? Are there occasional cases, and what kind of case would that be?
The ones that I'm most familiar with are criminal cases that involve constitutional issues.
So it would be a U.S. constitutional issue.
Yes.
Okay. How would you describe your judicial philosophy, if I may ask that question?
Well, and I get asked that question a lot. My judicial philosophy is most similar, I think, to Justice Scalia. He has written a book with Brian Garmer called Reading Law. And I actually use that book from time to time in trying to, what I see is properly interpret statutory gray areas. And I tend to be a textualist, and I do not feel that our courts should try to remake the law. We operate under precedent, and there are many, many times when I am writing a case and I'm just thinking, that's not the way I personally think the case should come out. And in some cases, I have written it in such a way that, not in an apologetic way, but in a way that emphasizes heavily the precedent that we must follow. So it can't be the law according to Justice Lambert, because Justice Lambert is only there for a short period of time.
Are there occasions, have you ever faced a case or decision where what's right, seemingly from a values or moral standpoint, might conflict, at least in part, with the law? Does that make sense?
It does make sense. I can't think of any particular instance that comes to mind, but I'm sure it's happened many, many times. One of the beauties of the law is that it has a structure to it, and people can rely on that precedent, and businesses can rely on that precedent. They know what the rules are about contracts, and they know what the rules are about state regulations and how those are interpreted. And the importance of the law is its steadiness and its dependability. And so we can't have judges and justices going off with their own unique ideas as to how something should turn out. We simply have to read the law and apply it to the facts, and leave most of the problem solving to the legislative and executive branches.
Are there instances in general that you've read about or studied or been involved in from your experience when the precedent that guides our system of decision making in the judiciary, as you noted, are there occasions when the precedent may need to be changed or modified or evolved?
Yes, there is, and I've never had that experience to where I was in a position of being able to do that. But at the Supreme Court level, the state Supreme Court level, then a panel of the 7 judges or justices, 4 could vote to change the law as it currently exists. That doesn't often happen, but at least at this level, it is possible for it to happen.
Can you conceive, without going in, obviously I'm not going to ask you a particular case or details of a case or even a hypothetical case, but in general terms, are there circumstances under which you could conceive of voting that way, or in the general type circumstances that would be required to break a precedent or to modify it?
Yes, I certainly think that we have to be able to leave ourselves open to that, because circumstances are likely to change, especially with technologies. Of course, technology's changed a lot since I graduated law school in 1989 even. And the law has changed less, but must change to meet the needs of the people from time to time. So it would be interesting to look to see how many precedent-changing cases come about in an 8-year time period. I may try to keep note of that.
That would be. I would be interested in that.
It would be interesting.
So and I don't mean to put. Did you say textualist? Is that
yes,
the term
I am
you used?
Yes, I did not use that term, but that is in fact a term that applies. I am a textualist.
Is a originalist, is that basically the same thing?
Very similar.
Describe that a little bit more, that philosophy or view of the law.
I think the view of the law as Scalia might describe it to a layperson would be that the words say what they mean and mean what they say, and you look toward the ordinary meaning of words without trying to embellish or build on the thought processes that you think that the author of the text may have had in mind.
Obviously, the late Justice Scalia was not an activist in the context of the judiciary.
He was not.
In terms of making law, if you will, for lack of a better term. Interpreting making law is one thing, but you would have, I would suppose, as a justice, on occasion, have to interpret the law.
Yes, that's all.
Am I making too much distinction there between making law, changing the law versus interpreting?
I don't think you are. I think that it is correct that part of what we do is attempting to interpret the law. With the LRC working with the legislative branch, they do a pretty good job of putting forth good legislation that can be interpreted fairly easily and isn't subject to a lot of judicial interpretation.
Okay. What's the role of the judiciary in terms of separation of powers between the three branches of the government?
Wow, that's a big one. There are three branches of government, and they are meant to be co-equal and hopefully in some sense cooperative and all working toward the good of the people. In our discussion before, we mentioned that I had recently sworn in some new office holders in a county nearby, and we all take the same oath to support the U.S. Constitution and the Constitution of the Commonwealth. And we all attempt to work for the good of our state and our country, and I think we can all do that in a collegial way. But there has to be a means of, in our design of government that was designed by people with bigger thought processes than mine, but there has to be a way of having a check and balance on each of us.
Can you conceive in general terms, again, without delving into specifics, of a circumstance where the judiciary might have to intervene and order both the other branches, if the executive branch and legislative branch were to impasse or simply could not make a decision? Would it be the duty or responsibility of the judiciary to take action?
Yes,
in such a circumstance.
It certainly could be. Let's keep our fingers crossed. So I don't have to do
we would certainly hoping that would never happen.
Yes.
That's not healthy for any of the branches to have to step in. Now, a lot of discussion about the selection of judges and justices. Here in Kentucky, obviously, you run as a nonpartisan candidate.
Yes.
And you had a primary. There were three candidates. You won the primary. Another gentleman came in second. Then the two of you ran in the fall.
Yes.
And you were elected. You serve how long?
8 years.
8 years. You can run again. There are no term limits.
No term limits.
But you are subject to every 8 years. Some states still have partisan selection.
Yes.
Some states have, if I recall my teaching of state government days, the Missouri Plan, where a commission or the governor appoints the state judges, and maybe they're subject to recall of some form or fashion. Is there a preferred way? Is that an appropriate question for you?
It is a very appropriate question, and I personally like, as difficult as it is to run an election, I personally like the current method that we use, the nonpartisan. A person should not worry about their political party designation when they come before a judge. The rules apply to everyone equally. And I like the elective process. In Kentucky, we do not have statewide elections for our appellate court judges, which I also think is good because it does keep down the cost of the election. Though elected from 27 counties, I do serve the entire state of Kentucky. In states where there are judicial elections that are statewide, the elections have become very, very expensive and very difficult to run. So I prefer our method.
It seems to have worked well.
Yes.
Here in Kentucky over the past many years since I think at one time we actually elected partisan a long time ago. I think it
I'm
may
not
have been
sure about that.
I'm not absolutely certain of that, but I think maybe before the new system of district judges and the new court system, we may have had partisan elections. But that's always an interesting debate, and I want to ask your comment on this. But at the federal level, of course, there's the debate: should judges serve life appointments? And
Yes.
that is certainly an emotional kind of debate, and depending, I guess, on the particular judge, whether he or she has ruled in your favor, may influence that particular
Correct, yes.
notion. One question from time to time that is discussed is to the extent that judicial proceedings should or should not be open to the public and to media coverage. Are there occasions, in your opinion, when the media or the public should not be in a particular proceeding, and if so, what type?
I do agree that there are certain times that the media should not be involved. Certainly, there are very sensitive issues regarding child abuse and neglect.
Good point.
Having been a family court judge, I'm certainly aware of those instances where the embarrassment to a child, particularly in a smaller community, would be profound. And I do support those concepts, though now there are some pilot sites in Kentucky where even juvenile dependency, neglect, and abuse cases are open, subject to the judge's discretion, saying no, this particular case should be closed. So I'm okay with that pilot project as
Sure.
long as the judge has the ability to close a case for the protection of the child.
Now, other type cases are open, is that correct?
Yes.
Are media allowed to actually video or tape or the proceedings, or are there restrictions on that?
I don't know of any restrictions. I know that when I was a trial judge doing cases that were not otherwise closed, media was welcome to the courtroom, and I've never known of a situation where they weren't. They usually would ask the judge in advance, where would you like for us to set up, and what can we do to stay out of the way? But it's never been a problem in my own personal experience.
The Chief Justice of the Supreme Court, how
Yes.
is he or she selected?
He is selected, or she is selected by the court members.
Okay.
And I believe, and I'm not sure about this, but I think that the term is 4 years.
Okay, sounds
I
correct.
think that's right, yes.
And the current Chief Justice is?
Chief Justice John Minton from Bowling Green.
Right.
Yes.
Highly respected, from
He is.
what I understand
He is.
and have
Yes.
observed. And I recently, the state Supreme Court reviewed the pension case.
Yes.
And obviously, I'm not going to ask you about that case, but it, I watched the proceedings, the arguments, but between both sides, and there was a certain feel to it, in a positive sense. A deliberative body. And both sides doing their very best to argue their case. And
Good lawyers on both sides.
exactly, they both did very well, and the 7 members of the court asking pertinent questions. And I sat there trying to read them. How's this going to go? Obviously, it was 7-0 in the ultimate decision. But it's interesting. I don't think the public has a feel for how judicial proceedings go, particularly at that level. Have you experienced that? There's kind of a mystery. Maybe they have an understanding of district court, or even they've been to circuit court. But you get to that level, there's a certain awe.
There is a certain awe, and hopefully it is the public trust and confidence can be maintained and is maintained over the years. As a family court judge and circuit judge, the decision was only mine at that moment. But on the appellate court bench, we sat in panels of 3 at the Court of Appeals, and it's a collegial decision between 3 people. What I'm looking forward to is, and what you don't see on that video, is
Right.
behind that wall
Exactly.
is a conference room.
Yeah.
And 7 people and their law clerks go back there after the argument and discuss that case. And I can't wait to be
Sure.
a part of that process. And it is a bit of a committee process because everyone
And all
has
7
voice.
would participate in that deliberation.
Yes, in each case.
How long, and this is obviously speculative to an extent, but how long would that deliberative process generally take on a typical case?
I am not sure, but I think that the immediate process is somewhat limited by what time is the next case coming up. But my understanding is that the deliberation and the tweaking and the editing can take some time. There is an online communication system that is used between the judges on cases to share comments back and forth about opinions.
Does a particular justice get assigned the case to write, and then the other 6 comment and
Yes, they take a vote, an initial vote, and assign someone in the majority to write the opinion.
Does the state Supreme Court ever have a minority opinion or dissenting opinion?
Yes, often.
Okay. I mean, I know that is the case in the federal courts. Very good. Well, we're out of time. I have really enjoyed this interview. I've learned a lot myself. Wish you the very best, and know that the citizens of our district and Kentucky will be well served.
Thank you very much.
Thank you. God bless you.
God bless you.
This is John Chowning with Supreme Court Justice Deborah Lambert in her first term on the Kentucky Supreme Court. We wish her well, and we thank you for being with us for Dialogue on Public Issues.